Good day, everybody. Good morning, good afternoon. Am I audible? Yes, okay. Welcome to our book launch this morning. We have the Marine Plastic Pollution and Rule of Law book launch. It is an endeavor of 4 institutions, APCEL, Asian Pacific Center for Environmental Law, National University of Singapore, and then the UC, University of Cebu School of Law, the KLRI, Korean Legislation Research Institute, Korea, and Konrad-Adenauer-Stiftung Rule of Law Program. Okay, so without further ado, I would like to introduce us to, I would like to call Dr. Jolene LIN, the Director of Asia Pacific Center for Environmental Law, Associate Professor in National University of Singapore Faculty of Law, to give an opening address for the launch. Jolene, the time is yours.
Thanks, Linda. And doing away with the formalities, thank you everyone for really taking the time to join us this morning here in Singapore, and some of you are joining us from other time zones, and really appreciate the fact that people are tuning in for the launch of this very important publication on marine plastics pollution and the rule of law. This is the accumulation of a large amount of work that started last year, and has been the result of a collaboration, a very fruitful collaboration between the Asia Pacific Center of Environmental Law, the Korea Legislation Research Institute, and the University of Cebu School of Law. And we are very grateful to Konrad-Adenauer-Stiftung for their support throughout this process. This publication could not be more timely. The project was conceived slightly before the start of the COVID-19 pandemic. And the fact that it had on the side of, on the aspects of the project that had to be radically overhauled in light of travel restrictions, etc. I like to give a lot of credit to the people leading this project, Linda, Rose-Liza, and Jion, for really being very dynamic and adaptive to the challenges that we faced in putting together this publication. On a sobering note, this publication is very timely because the COVID-19 pandemic threatens to roll back years of slow progress in dealing with marine plastic pollution. Recent studies have estimated that the amount of plastic waste generated worldwide since the outbreak of COVID-19 is about 1.6 million tons a day. And average estimates, which I think is supposed to be an underestimate, it is an estimated 3.4 billion single-use face masks are discarded daily worldwide as a result of COVID-19. And needless to say, for many of us, it would be familiar to know that in many of our countries, lockdowns have meant that restaurants and cafes have had to stop operation and only provide takeaway services. As a result, takeaway food containers, single-use plastic bags, plastic bottles, disposable coffee cups, all these are some of the most prevalent plastic waste that we see today in the oceans. And it is terrifying to know that instead of making progress at a critical time in the health of the fragile marine environment, we see a significant threat. And I'm hoping that this book and our collective efforts will try to bring together some ideas, some energy, and some collaboration to really try to see how legal instruments, whether at the local level, regional level, or at international level, can be devised and better implemented to address this significant challenge. Thank you.
Thank you, Jolene, for the enlightening opening address. I would like to introduce to everybody about the book, actually. Just like Jolene was saying, it's a collaboration of For institution, APCEL in NUS, Konrad-Adenauer-Stiftung Rule of Law Program. And then in Korea, we have the Korean Legislative Research Institute. And in the Philippines, we have University of Cebu School of Law. So we came up with the idea because the issue was very prominent. Everybody was in COVID in 2020. And then, but we see like in the academic sphere, there aren't that many papers or academic assessment in addressing the marine plastic pollution problems. At that time, 2 of Southeast Asian countries were on the top of polluting the marine with plastic, and also China was #1. So there were a lot of Asia Pacific countries that are struggling with marine plastic pollution. So we're thinking of harnessing, best practices and challenges that we face in the region through our academia, students, whoever that were interested in the issue. So we did a call of paper at that time for the marine plastic pollution in Asia Pacific in July 2020. And then we had very good abstract submission in August 2020. And then from I think it was about 40 abstract submission, and then we had to select these abstracts, and then we started with a webinar to brainstorm ideas from the presenters. So what do they want to write? What are the research questions, and whether this is like applicable to what we were going to envision the book for. So, and then we ended up in paper submission in October 2020. We ended up with 11 articles and papers. So some are longer than the others, and some are regional, some are international and national, but some are national and local. So I think the book is a collection of many issues that we have in the marine plastic pollution rule of law. So we have 11 contributors for this book that you will be able to access for free online. It's hosted in the APCEL website and also in the CAS website. And pretty soon we will have the EPUB version. Currently we have the PDF version online. But everybody that has contributed to the book, I would like to say a great thank you from the bottom of our hearts, because we know it was not and still is not an easy task to do, to discuss this issue and also to put them on paper and do everything amidst your all activities and busyness during COVID. So in this month, October 2021, we finally managed to come up with this publication that we would want most of you to read and also discuss, and hopefully will be intriguing for you to do a further research. Without further ado, I would like to invite the Director of Rule of Law Program, Konrad-Adenauer-Stiftung Asia, my dear friend, Stefan Samse.
Well, thank you, Linda, and thank you, Jolene. Good morning and welcome on behalf of the Konrad-Adenauer Foundation, KAS. It's great to see and meet you today. At KAS, we are at the same time happy and proud to be involved in this project. Let me just very briefly explain why. Well, our networks at KLRI, UC, NUS APCEL, and KAS are partly overlapping anyway. So it is joyful to work with you on this trusted and long-term approach. Our approach, however, is not only long-term, and that's a key thing that has been mentioned before today. this publication is very, very timely. Marine plastic pollution, marine debris, and the rule of law, just a few keywords looking at today's and yesterday's headlines in the news. I mean, it was just yesterday that the European Union's climate chief, Frans Timmermans, has been in Jakarta for consultations. And, a military alliance very far away from the region we are meeting in today, NATO has recently set up a center of excellence in climate change, environmental matters, and security, defining climate change as the major threat. So, in other words, our publication will be a very helpful tool that we can use both ways, Asia, Europe, Australia, and the other way around. So, walking along Singapore's east coast, for example, I mean, I would not be surprised to encounter the remainders of a PET bottle that someone has tossed into the Elbe River in Hamburg. So it is truly a global challenge. And I do think that environmental issues are on the citizens' agenda in Europe and far beyond. All polls ahead of Germany's national election that took place last month identified and indicated climate issues as the #1 topic, far ahead of issues like fighting the pandemic that has changed our lives so much. So there are campaigns, of course, in Europe and elsewhere to raise awareness when it comes to marine plastic pollution. However, compared to other environmental issues, such as the future of coal power plants, for example, a further boost to our agenda would help. So again, this publication is a great tool that we can and that we will use to spread the analysis, the information, the knowledge within our environmental policy networks in Europe, as well as in the region here, and also within the legal networks that we have. At the end of the day, we are targeting lawmakers, members of parliament, of the parliaments, who are key to setting new legal standards in environmental law. So your analysis and the best practice examples we've seen and we can now read will help us to do so. Let me once again thank the authors for their contributions, and of course very much so dear Linda and dear Lisa for the enormous amount of time and energy that you've invested to put it all together. Also, of course, at KAS Rule of Law Program Asia, Susan, for managing the whole project on our side. Looking very much forward to today's presentations and the discussions. Thanks a lot. Thanks a lot.
Thank you, Stefan. And next, remarks from my dear co-editor, Rose-Liza Eisma-Osorio. She's a professor in the College of Law, University of Cebu. And then she is also Legal and Policy Director in Oceania, Philippines. The floor is yours, Lisa.
Thank you, Linda. Good morning, dear colleagues, friends, and participants. Mabuhay. It is my extreme honor to be part of this book launching, finally, of the Marine Plastic Pollution and the Rule of Law publication. In behalf of the University of Cebu School of Law, please allow me to convey our warm greetings and congratulations to the other partner institutions in this endeavor, the Konrad-Adenauer-Stiftung, Korea Legislation Research Institute, and the Asia Pacific Center for Environmental Law, National University of Singapore. I would also like to thank the authors who have contributed their articles for this publication. The Marine Plastic Pollution and the Rule of Law book showcases cutting-edge work from thought leaders in environmental law in the Asia Pacific region. Personally, I really enjoyed editing all the articles because it presented legal research policy perspectives on plastic pollution and its impacts on the marine environment from eminent academics, policy advocates, and legal practitioners in the Asia Pacific region. Marine plastic pollution is a problem that the world desperately needs to address. Many solutions fix the worsening plastic wastes have been determined. However, one intrinsic aspect that we need not forget is really that the solution to the plastic crisis can be done through the rule of law. Many states nowadays, cities, towns, have begun enacting laws, ordinances, and other legal instruments banning the use of single-use plastics. But a lot more steps are needed towards the rule of law. According to the UNEP, there are 3 interdependent components of environmental rule of law. First, environmental law should be consistent with the fundamental human and legal rights. Second, environmental law should be inclusively developed and fairly implemented. Third, environmental law should achieve accountability to observance and compliance. And I would like to emphasize the last one, which we sorely need, especially in a country where I'm living in, which is the Philippines, the 3rd largest contributor of plastics in the world. So we must therefore ensure that aside from fully having implementable laws, there must be, among others, clear mandates of institutions which are tasked to implement these laws. Citizens must be given access to information, public participation, and justice. There must also be accountability in cases when environmental institutions fail to discharge their responsibilities. Today, almost all countries have enabling legal frameworks for environmental protection at the national and local levels. Recently, we had the UN Human Rights Council also declare the global human rights in the environment. So there is really an unprecedented growth of these national environmental framework laws. But despite all these advances, there's still a mismatch between existing laws and socio-ecological systems. This is what is evident in the story of a waste speaker that I want to share with you today that I met in Cebu. She lamented that with the mounting problem of plastics, it is much harder for them to earn their livelihood from picking recyclable materials to sell for their daily needs. She noted that she has less income because plastics, especially single-use plastics, are mixed together with other sellable recyclables, making her also work longer hours away from her family. She acknowledges that government must implement the 20-year-old law on solid waste management in the country, which mandates the National Solid Waste Management Commission to phase out non-environmentally acceptable products. When I first talked to her, she sounded tired after a day's work, but she was determined for a change. For this reason, she has joined 49 other plaintiffs, majority of whom are youth and minors, fisherfolks, lawmakers, private citizens, and public interest organizations, in urging the Commission to immediately issue a regulation to control the production, use of these products, including single-use plastics. This is her story, a story of injustice that many of us here cannot imagine happening to us. And this is just one story about plastics. So here in the Philippines, we're actually preparing for a litigation to sue the government in order for them to address the mounting plastic crisis that we're having in the country. This is what's making me also busy nowadays. So we need to navigate through rough waters in the years to come. While there are many noteworthy initiatives that we can learn from this book, there are still many windows of opportunities that are left unopened. We need to continue navigating through our seas of plastics and try to move towards long-term, inclusive, and just approaches in order to deal with the plastic crisis we're facing today. Good morning again to everyone, and mabuhay.
Thank you, Oz. Now our last remark from Korea Legislative Research Institute in South Korea, my dear friend, Jeon Choi. She's a senior research fellow at the KLRI, South Korea. Time is yours, Jeon.
Thank you, Linda. Hello, everyone. Well, first comes first, I have to thank you, Linda, Rose, Jolene, Susan, and the rest of the team, and all participants who has put together hundreds of hours into this project, for giving me an opportunity to be part of this wonderful journey. Thank you. As a person with little expertise in marine plastics, pollution, and environments, I am extremely humbled and honored to participate in this project and observing it through to this, I would say, a glorious day of the book launch ceremony. Congratulations for all of you. The idea of me being on board for this international workshop with those impeccable group of scholars and practitioners And working with them was something beyond my imagination at first, and I was fortunate enough to be the link between Korea Legislation Research Institute in APCEL, U of Cebu, and Konrad-Adenauer Foundations, Singapore. Through this journey, KRLI has entered into a partnership, an official partnership with APCEL, U of Cebu, and Konrad-Adenauer Foundation, Singapore. Even under this never experienced threat by COVID, scholars in those organizations pulled some special strings and made this not just possible, but a success. And I cannot wait to see what we could do, even when we could actually meet together face to face in person next year or maybe in the future. So again, so much potential in those participants, and my dear editors, Linda and Rose, and the team had run extra miles to pull those potentials out and be seen. Jolene, Linda, Rose were generous in including me as the workforce getting this job done, but I have to confess that I have contributed only a teeny little bit in the beginning, and Linda and Rose have hard carried this project all along by themselves. So I would like to conclude my remarks thanking the team for bringing this book to the world, and I hope it be another stepping stone for reducing pollution and saving our planet. Thank you.
Thank you so much, Gian. Okay, so we have all of our addresses and remarks for this joyful event opening. Now we come to the teaser part of the event. So as I told you earlier, we have 11 articles and papers. Before we start, I would like to give this nudge for Alice to get ready. I would like to read first, like all the articles that we have. We have the first article that is going to be presented by Dr. Alice Palmer. She's going to present on regional solution, export measures for plastic recyclables to reduce marine plastic pollution in the Pacific. So it's very interesting ideas in the articles. The most challenging thing is how Alice is going to present this in 15 minutes. The second article is by our dear friend also, Jonathan Liljeblad. He's talking about littoral indigenous communities and transboundary ocean plastic waste in Southeast Asia, potential approaches in international human rights law. Third article that you'll find in the book is written by our dear Rose-Liza, Eisma-Osorio, Navigating Seas of Plastic, a critical reflection on the legal responses in the Philippines to marine plastic debris. The fourth article is by myself. I wrote on, it's actually descriptive marine plastic pollution regulation in Indonesia, very short, but I do like an extensive research after that, not in the book, but stay tuned. And then our dear friend, Anton Ming-Zi Gao from Taiwan, wrote the fifth article on measures to counter plastic marine debris in Taiwan, a holistic approach. He's a professor in NTU Taiwan. And then from India, we have Rahul Kudori and Ritwik Dutta on fixing liability for marine plastic pollution. In that article, they are discussing a lot about cases in India on marine plastic pollution and how to pinpoint liability problems there. And then the seventh article is by our dear Pei Xuan Chang, who is here at the moment, and she will present, she will be the second presenter after Alice. She wrote about marine plastic governance through international law in China, international commitment and state practice. Pei Xuan is a PhD student, but we'll know about her later on. And then our eighth article is by our dear Rocky. Rocky is also here. He will present it today after Pei Xuan. He wrote about status, trend, and best management practices for ALDFG in Asia Pacific, which we will hear more about. The 9th article is about Vietnam, specifically solid waste and marine plastic pollution, and how solid waste management can lead to marine plastic pollution, by Dang Nguyen, or we call her Daisy. And then 10th article is on closing the gap between national and the global regional and market-based approach to end plastic pollution, by Eric B. And then the 11th article is on legal practice and future prospects of marine debris management in China, by Ruilong Yin. So that's the list of the articles and papers that you will find in our book. So now the first teaser from Dr. Alice Palmer, who is a senior fellow in the Melbourne Law Master's Program. She wrote the article together with her colleagues in Melbourne Law. And let's hear it. 15 minutes for you, Alice. Time is yours.
Thank you so much, and greetings everyone. Yes, I'm joining you from Melbourne, Australia, the most locked down city in the world. I'm here on the lands of the Wurundjeri peoples, our First Nations people. I pay my respects to their elders past and present. I want to thank the editors, Linda and Rose-Liza, and of course, Jolene and the rest of the team at the Asia Pacific Centre for Environmental Law for this invitation and this opportunity to contribute to this marvellous book. Thank you so much. I'm just going to share my screen and try, as I was invited to by Linda, to try and get through quite a lot of extensive information from this chapter contribution. So, as Linda explained, I co-authored this with Professor Jackie Peel, Professor Lee Godden and Ms. Rebecca Markey-Towler. I'm going to be speaking very briefly about the context of this particular contribution for the Pacific Islands, and that's then going to take me through to talk about domestic measures. And by domestic measures, I'm referring there to the measures that are implemented in countries at the national level, and then before going through and looking at international frameworks, regional solutions, and pausing on the final conclusion, talking about the importance of a life cycle approach in addressing marine plastic pollution. Now, the context for the Pacific Islands is actually one that is, in many respects, one that you're all familiar with, especially after the story we just heard from Rose-Liza about the situation in the Philippines. I'm sure this is something that everyone's is going to resonate with everyone. But of course, there are particular aspects of Pacific Island countries that make them uniquely placed in terms of the challenges that are presented by plastic waste, certainly, but they are also uniquely placed as leaders in developing laws and policies to address the problem of plastic waste before it enters the ocean. So many of the 22 nations are archipelagos with clusters of small islands in this vast ocean region, and their reliance on the sea for their food, for their transport, tourism, and that's just to name a few, means that they're particularly vulnerable to the effects of marine pollution, and their small land mass means that options for dealing with plastic waste in their countries is significantly limited. And those that depend on tourism, and there are quite a few Pacific Islands that do, have been especially hard hit by the travel restrictions of the COVID pandemic, and their already very small economies have been pushed even further to the limits in terms of being able to implement what is ultimately a very costly waste management process. But necessity is the mother of invention, and many Pacific Islands have either developed or are developing domestic measures that take a holistic approach to regulating waste. So as I said, when I say domestic measures here, I'm referring to those steps that are taken within the country as opposed to the sorts of laws and measures we might see internationally. And this holistic approach by Pacific Islands has seen them regulating waste at what we in the chapter are described as three different stages. First, at the point of entry, second, in country, and third, at the point of exit from their national jurisdictions. So at the point of entry, they might place limits on imports of plastic in an effort to reduce the amount of plastic waste entering the country in the first place. And that might take the form, for example, of import bans on single-use plastics or takeaway, silverware, etc. And this is important for Pacific countries, which really rely very heavily on imported consumables that generate plastic. Then countries have looked at the management of waste in their countries, introducing a range of measures to incentivize the collection and recycling of plastic waste. Several countries have, for example, introduced container deposit schemes, where many of you will be familiar with those sorts of arrangements, where a small fee is paid by importers or otherwise added to the cost of a product, which is then paid by the consumers, and it is then refunded to the consumers or to the importer when those spent plastic bottles, the empty plastic bottles, are returned to a collection centre. Once the plastic has been collected, however, Pacific Islands don't typically have the capacity within their countries to recycle it. The economies of scale to recycle the plastic that they generate is just not economically viable, and so the countries often encounter difficulties storing that plastic and have to find ways to export it. So it's then at the point of exit that Pacific Islands have been taking steps to make producers responsible for the waste generated by their products. And under certain company policies or negotiated arrangements, these used products are returned to the producer to manage the waste through recycling or recovery. And there are many large manufacturers of beverages or electronic products that have these sorts of arrangements in place as part of corporate responsibility policies. But the markets for post-consumer plastic waste are very limited, even more so since China restricted imports of contaminated plastic waste for recycling, and especially for small islands where the shipping costs of getting these plastics off island can make it economically unviable. So one way of addressing the economies of scale is to look at the international laws and programs, but as I will explain next, these are limited in what they can achieve. The existing treaties directed at waste management at the international level are important for guiding the domestic or national measures and policies, and they include such things as the Basel and Stockholm Conventions, which deal respectively with transboundary movement of hazardous waste, and in the case of the Stockholm Convention, persistent organic pollutants, and of course the UN Convention on the Law of the Sea. But this patchwork of treaties is very fragmented. Their scope is limited by the specific areas that they regulate. So, for example, the Basel Convention is ultimately confined to transboundary movements of particular kinds of waste. So despite the very important amendment agreed in 2019 that brought certain plastics under its reach, the Basel Convention and other international agreements are necessarily limited in how far they can go in fostering the, if you like, the holistic or integrated waste management approaches across the life cycle of a product, including products that generate plastic waste. So if you like, they're only capable of dealing with one part of this puzzle. In order to address those gaps at the international level and recognising the challenges that are faced domestically, our chapter in this wonderful book proposes that particular efforts be made regionally to deal with recyclable waste at the point of exit. That is, finding ways to get plastic out of the Pacific Islands so that it isn't accumulating endlessly and at risk of entering the ocean. And these can emphasise life cycle solutions that are tailored to the particular conditions of the particular challenges that are faced by small island countries in the Pacific region. So the refusing and reducing of plastic waste at the entry points in terms of imported goods and packaging is very much part of the solution, but getting it off the islands in a condition for recycling is ultimately critical for dealing with the plastic waste that's generated from consumables that do inevitably find their way into the country. There's no avoiding some element of plastic waste. And so it's here that regional treaties and soft law programs are really very vital to addressing these problems. So you have treaties such as the NUMEA and WAGANI conventions that do some of the same work as the international treaties, but with a regional orientation that can be much more responsive, if you like, to the particular circumstances of Pacific Island states. So for example, Article 10 of the WAGANI Convention, which mirrors provisions of the Basel Convention, provides for regional cooperation in hazardous waste management, including making sure that adequate treatment and disposal facilities are available and maintained within the Pacific region. That's actually part of the convention requirements. And this, in our chapter, is what we maintain would include the creation of regional facilities, such as recycling hubs located in one Pacific Island country capable of processing the plastic waste for recycling from other Pacific Island states. There are also numerous soft law programs that are developed as part of the regional governance structures, which are critical to addressing this problem. And the non-binding nature of those initiatives is a real advantage in being able to respond and develop over time. These programs are supported by various regional institutions and networks. And indeed, it was our work looking at waste regulation in the Pacific region, which was commissioned by SPREP, the UN Secretariat of the Pacific Regional Environmental Program. They asked us to do that as part of an initiative known as Packways Plus. And that informed much of our thinking for this chapter in both identifying existing laws and policies within the Pacific Island countries, as well as identifying opportunities for regional coordination efforts. It was through that work for SPREP that we were able to understand some of the matters associated with a whole range of public-private partnerships, including some specifically aimed at this issue of getting recyclable waste off Pacific Islands. And this includes the Moanataka Partnership, which is an arrangement between SPREP and the China Navigation Company to reduce waste streams that are accumulating in Pacific Islands. And this partnership allows certain Pacific Island countries to request shipments of waste by swire shipping at greatly reduced costs by using shipping containers that the company would otherwise be shipping empty. And it's currently restricted to non-commercial hazardous wastes, but we in the chapter proposed that these could be extended, that there are opportunities to scale up these arrangements to facilitate the export of recyclables, particularly plastics, by reaching out to different shipping companies to negotiate reduced transportation costs of getting waste to export markets. These sorts of initiatives require the support of regional governance structures, and these include such things as arrangements to support the recycling hub idea that I flagged earlier, as well as arrangements to facilitate the shipment of waste for recycling between islands. The capacity building to improve in-country waste management so that it is fit for recycling. As Rose-Liza was explaining earlier on, these wastes often get mixed and they're not always stored in a manner that means that they're kept to the right quality for recycling. And linked to this, the development of common quality standards for recycled plastics is also an important initiative that regional institutions and structures can facilitate. And finally, the engagement with global initiatives such as the Basel Convention Partnership on Plastic Waste, which is a multi-stakeholder forum which gathers information and developing strategies for the management of plastic waste in consultation with relevant businesses and civil society. So the regional structures are really important for being able to engage also with those international initiatives. That brings me to my conclusion. The plastic pollution, as we heard from our introductory speakers, with all the statistics and stories that they just shared with us, we know that pollution is one of the many threats to the health of the world's oceans. But our conclusion for the chapter is that in the face of this particular threat, Pacific Islands have really been leading the way with the enactment and implementation of very innovative laws and measures that apply within their own countries. And this innovation has really created opportunities for regional action, with individual countries combining their efforts effectively to deal with plastic pollution. And of course, their efforts, both domestically and regionally, are very important models in life cycle approaches to waste regulation, with some able to lead within the region, but also able to lead globally in showing what can be achieved through laws and programs dealing with plastic waste before it enters the ocean environment. That brings me to my end. Thank you so much. I'm very much looking forward to hearing the other speakers and joining you all for the discussion. Thank you.
Thank you, Alice. Very insightful and very on time. I would like to invite our second teaser, Pei Xuan Xiang, to be ready to present her paper. Pei Xuan is a PhD student in international law at the School of Law at Tsinghua University. And I think she briefly, like a few months ago, passes the candidacy of her PhD, right? Congratulations, Pei Xuan.
Thank you, Linda.
Okay, the time is yours, 15 minutes.
Okay, thank you. So I will start to share my PowerPoint. Just a moment. Yeah, thank you very much for the committee to make this event happening and to bring this book to the world. It is my great honor to present my chapter, which is titled Marine Plastic Governance Through International Law in China, International Commitment and State Practice. So today I will firstly give a brief overview of the marine plastic pollution situation in China as the general background. And then I will introduce the status of China's participation in the existing international legal architecture, including the binding treaties and also the soft law instruments. And also I will examine what has China done in implementing the international commitment that it has made by joining the international legal architecture. And then, since the international legal lawmaking process is still on the way, so I will give an introduction of what China has done in participating in this development process, and then I will draw some conclusions. So firstly, marine plastic pollution is both international pressure and domestic demand to be tackled that is faced by China. In 2016, China ranked as the 4th largest marine plastic waste generator. And before that, in 2010, China ranked in the 1st place. And it had the 5th largest volume of the mismanaged plastic waste generated by the coastal population. And China has the world's largest coastal population. And also, according to the official statistics in China, in 2019, the plastic items accounted for from 80% to 90% respectively of the total amount of the litter that can be found in the surface of the sea or in the beach litter and the seabed. So as for China, when tackling marine plastic pollution, the 3 challenges it faces are the large volume of domestic consumption, and then it has imported the plastic waste from, especially from the industrialized countries. And also, China is still lacking the sufficient capacity to manage the plastic pollution either generated domestically or imported from other countries. And this table gives you an overview of the international treaties that are applicable to marine plastic governance that China has already participated in. So from the as for the pollution-oriented treaties, China has been the party to the UNCLOS and the MARPOL Annex 5, and also London Convention and its protocol, so that dealing with the pollution generated from vessels and from dumping and partially from the land-based activities. And secondly, the chemical and waste-oriented treaties, the mainly dealing with this issue are the APCEL Convention and Stockholm Convention. China has already participated in these two instruments. And also, as marine plastic pollution also will affecting the biodiversity. So here I also listed two conventions that are Convention on Biological Diversity and also United Nations Fish Stock Arrangement. So as you can see, China does not fall behind any other country in terms of participating in the international legal architecture. And also China has already actively participated in the international soft law instruments such as the Honolulu Strategy and the 2030 Development Agenda that is endorsed by the United Nations General Assembly, and so on and so forth. And if you look at the text of the treaties that China participated in, the major substantive obligation is to adopt appropriate domestic measures, including policy and legislation, to fulfill the treaty objectives. So as for the plastic pollution per se, there are two domestic legislations that are highly relevant regarding the marine plastic pollution in China. The first is Marine Environmental Protection Law, which was adopted in 1982 and was recently amended in 2017. So in this law, it deals specifically with land-based pollutant, coastal construction projects, marine construction projects, dumping of waste, and by vessels. And if we compare the text of the China's domestic law and the international instrument, you can find many of the provisions has been aligned with the international treaties. And also in this law, it holds the primacy of international treaties when there is a contradiction between the domestic law and international law. And another one is Solidworks Law. It was adopted in 1995 and was recently amended in 2020. This is very important because it's the first law in China that introduced a plastic ban. And it also introduced waste sorting as the legal obligation. And compared with the previous versions of this law, it increased the penalty for violation and added more provisions to encourage scientific research, innovation, and even for whistleblowers. And we can also find many internationally recognized principles in the international environmental law are included in this Solidworks Law, such as the extended producer responsibility and the environmental assessment, and also polluter pays principle. And what is more important is that in this law, it sets the target that China has to realize the zero import of solid waste as the target. So this brings me to the very well-known Chinese import ban. It was actually developed step by step from 2008. So in 2008, China announced prohibition of the importation of certain kind of plastics to be imported into China. And it has followed in a gradual development in 2003 for enhanced implementation. And in 2017, it added more plastic waste onto the blacklist. And finally, on 2020, accompanied with the newly amended Solid Waste Law, it banned any solid waste import from any country in any means. So it is the strictest fine, and it's aimed to enter into force this year. So China's import ban has changed the geographical landscape of the global plastic trade. And most of the plastic trade, plastic pollution, was originally intended to be exported to China, rerouted to countries, especially in Southeast Asia. So it is a great surge. There is a great surge in its ASEAN region in terms of the plastic waste import. But on the other hand, this also serves as a catalyst for ASEAN countries to declare their own war against plastic waste import. So we can also see the plastic import ban adopted by Thailand, Malaysia, and Vietnam, and also the ASEAN as the regional institution also made their declarations and action plan in combating marine debris. And on the other hand, in addition to adopting domestic measures, China has also fulfilling their treaty obligation to join in the multilateral cooperation framework, including the UN framework and also the regional institutions, as well as bilateral cooperations. So there's a general overview of the current situation. As we know, currently, we do not have a international binding treaty that's tackling marine plastic pollution per se. As our first presenter, the professor mentioned that the current landscape of the legal architecture is very fragmented. So we have three options to develop the international legislation. The first is maintaining the status quo, which is not recommended. And second one is revising and strengthening the existing framework without adopting a new one. And third one is developing a new internationally binding treaty that's specifically tackling a plastic issue. So what is China's choice? Although there's no official position paper that's submitted by China to the UN, but we can infer its attitude from its actions that China is preferred. It's the option 2 is preferred by China because there's no ambitious stance on the international fora that's made by China, explicitly calling for a new one. And also, if we look at its domestic actions and also its attitude when participating in the international and regional arrangements, it shows that China is upholding and complementing the existing international instrument and by enhancing the existing one. And always China prefers the voluntary measures instead of taking the binding new obligations. So how to enhance the existing international architecture? China taking a kind of divergent approach when it's making its contribution to this development process. Firstly, I will use the example of the amendment in Stockholm Convention because it made an amendment, added some chemicals that is highly relevant to the processing of plastics items. It's a very important step forward, but China did not accept it because the chemicals that added into the annex were very important for Chinese industrial. China is the biggest user and producer of these chemicals, and also China do not have the capacity to reduce the volume. So China did not accept this development. But on the other hand, when it comes to import of plastic waste, China tends to be very errant-handed. When the Basel Convention made amendments, China did not accepted at first, but then now it accepted. But my observation is that China does not satisfied with the exceptions made on the in the plastic amendment of the Basel Convention, because certain kind of plastics still not subject to the PIC process. But as I mentioned before, China has already adopted the zero import target. So its domestic law is much stricter than the international pollution. So in the new waste law, China just deleted the supremacy of international treaty in its domestic law and upheld the primacy of domestic law when there is contradiction. So it upheld the stricter standard. So it brings my conclusion. First, as in this chapter, I use China as a case study to show that states are the authors, addresses, and guardians of international law concerning marine plastic pollution. So in this regard, state practice is very important, not only in terms of implementing the existing international commitment, but also in this process, the state's actions and legislations will, on the other side, influence the development of the law in the future. And also, I want to mention China in the beginning of this year adopt its 14th five-year plan. It said that China will establish the ecological and environmental governance based on the principle of the coordination and integration of land and sea. And it is pledged to not only participate actively in the international cooperation of environmental governance, but also to lead the process. So in this regard, I think we can expect more solid efforts from China's side in combating marine plastic pollution. And that brings me to the end of the presentation, and thank you for listening.
Thank you so much, Pei-Xuan. We'll keep the questions for Pei-Xuan and Alice until the end of the presentation sessions. We still have one more presentation, another teaser from Rocky Guzman. Rocky is a deputy director and a concurrent fellow at Asian Research Institute for Environmental Law. And he will enlighten us about ALFG. Yes. In ALDFG, lost or otherwise discarded fishing gear in Asia-Pacific marine situation. Please, Rocky, the time is yours, 15 minutes.
All right. Thank you very much, Linda. Good morning, good afternoon, good evening to everyone. My name is Rocky Guzman. First of all, I'd like to congratulate the team for finally making this happen. Good job to all of you. And I'm very honored to share this study as a teaser to the Marine Pollution Rule of Law book on marine debris. So as stated, I'll be discussing ALDFG, abandoned, lost, and otherwise discarded fishing gear in the context of Asia-Pacific. But for these purposes, I will just be referring to ALDFG as ghost gear, as it is more popularly known. So first of all, I'd like to thank the Asian Development Bank, but because this research has been funded primarily through a project with ALD for the management of plastic pollution of the Asian Development Bank, and I'll be happy to discuss the context in Asia-Pacific for this report. Now, for the vast majority of marine pollution, and especially in Asia-Pacific, and those that have been studied, these are from land-based sources. But a sizable portion of it has also been from ocean-based sources, which are primarily from fisheries, from shipping, from offshore platforms, and from aquaculture. Now, I'm going to focus on the marine pollution specifically from the fisheries sector, and this includes the gear, such as capture fishing gear, nets, traps, spots, fish aggregating devices, which are temporary structures that attract pelagic fish offshore, and fish packaging and other equipment. For the issue of ghost gear and the marine pollution from fisheries sector, it's estimated that up to 640,000 tons are introduced to the oceans each year. And this comprises of at least 10% of marine debris globally, although occurrence of this is highly variable based on locality. For instance, in remote areas and islands, which are a lot of them are dependent on fisheries as their main sector, they are responsible for up to 90% of the marine debris in these areas. And a lot of marine debris have also been entangled on the seabeds. And in some areas, such as the Mediterranean, up to 34% have been found to be ghost gear in those areas. Now, globally and in general, the causes have been varied, but primarily they have been through enforcement factors. For example, the prevalence of IUU, or illegal, unreported, and unregulated fishing, which makes them more likely to abandon their gear at sea. Then there are spatial pressures, which include gear conflict. Then there are operational factors as well. It makes it easier in the operations of fishing to just leave the gear at sea. And environmental conditions, which includes the seabed and weather conditions, if it's easier for fishing gear to get entangled and snagged underwater. For the legal and policy framework for this teaser, I'm just going to give a brief rundown of the international and regional instruments that have helped the management of ghost gear. The first two, I guess, for international frameworks are marine pollution governance frameworks and fisheries governance frameworks. They all have revisions in their conventions that are related and try to address the issue of ghost gear. On marine pollution governance frameworks, this includes the MARPOL Convention, which tries to address the discharge of waste from ships and prohibits actually the discharge, which includes synthetic ropes and fishing nets. And also the London Dumping Convention, which prescribes preventive action for dumping of wastes at sea. Now, on fisheries governance frameworks, there are certain conventions and instruments that try to address ghost gear as well. Of course, the framework convention is the Law of the Sea Convention, and then as an implementing agreement, the fish stocks agreement also contain provisions which try to address the management of fishing gear, specifically on gear marking. And also there are recent developments such as the Food and Agriculture Organization's Port State Management Measures Agreement, which try to address the issue of IUU fishing, but by making it illegal to land fish catches in the ports. Now, there are also soft law instruments, including the Code of Conduct for Responsible Fisheries and the voluntary guidelines for the marking of fishing gear, which is very important to prevent the proliferation of ghost gear through gear marking regulations. As the regional instruments, there are instruments such as the UNEP Regional Seas programs. In Asia Pacific, it's primarily through the Coordinating Body of Seas of East Asia, which manages this. And then there are also regional fisheries management organizations, which have implemented conservation and management measures, which attempt to address ghost gear. And also regional plans of actions, including regional plans of action on marine litter and illegal and unreported and unregulated fishing. Now, for the Asia-Pacific context, I'd like to focus really on what's happening here, because there aren't a lot of studies focusing on this region. Especially, most studies have been focused on, in this region at least, have been focused on developed countries. But in the few number of studies here, it was found that in developing Asia Pacific, most ghost gear prevalence have been due to, has been attributed to the small scale and artisanal fisheries, which includes the gear of gill nets, traps, spots, basically passive fishing gear, or those that are mostly stationary. And then, for example, some studies in Myanmar show that because of the economic conditions, there have been the practice of deliberate discarding to save on both space and fuel. And also in Indonesia and Australia comparative study, it was shown that Indonesians do not repair or replace nets as frequently. So this leads to the wastage of fishing nets, because they are not their use is not as maximized as compared to their Australian counterparts. Now, these studies show that the issue of ghost gear and ALDFG links to local conditions and development issues, specifically here in Asia Pacific, and the magnitude depends on the socio-economic status of the fishing sector. So a lot, aside from the global causes and the general causes that I've mentioned later on, some of the causes that are very specific and that are very pressing in this region includes IUU fishing and enforcement factors, operational issues such as what I mentioned, that's what's happening in the practice in Myanmar for saving fuel, discarding gear to save fuel. Then there's also the lack of waste management infrastructure, including port reception facilities and recycling facilities, and also the issue of the lack of the capacities and the need for more development of human and technological capabilities to address ghost gear, as well as monitoring capabilities of governments here for the management of fisheries that would also address the ghost gear issue. Now, just a quick rundown for this teaser on the best management practices. There are three general categories of how to address ghost gear. The first one is on prevention measures, which includes the disposition and the management of gear. It's good gear marking and installing gear location technology on the gear. Then there are also the interventions in the ports, which includes port state measures and having port reception facilities to collect the gear that should be disposed already. Then there are also spatial management measures, which are envisioned to really to address the gear conflict and ensure that there are certain zones in the sea where gears can operate. And then there are also circular economy and design considerations. For example, vessels could be designed in a way that there are storage areas for waste and nets. And there are manufacturer involvement interventions that could be done as well, which include buyback and refund schemes and the need to maximize reuse and use high quality materials for fishing gear instead of the low quality ones. Then there are also the general interventions, which includes reducing fishing effort and addressing IUU fishing through improved fisheries management, to improve transparency, and to have more deterrent measures in general to really eliminate and curb IUU fishing that would lead to lesser incidents of ghost gear in the oceans. Now for the mitigation and curative, the next interventions include the mitigation and curative steps that we can take, that governments can take. For mitigation, it includes having biodegradable gear and having technology that would try to mitigate the impacts and when the gear is already lost at sea. This includes beacons and pingers and reflectors for our marine species to avoid getting caught and tangled in the ghost gear. Then there are also the curative measures that are predicated, that these mitigation and curative measures are already predicated with that the ghost gear are already at sea. For curative measures, it includes the 3 R's, I would say, for this issue, which is reporting, which includes surveys also of the sea, and then there are recovery programs and also recycling programs later on. Now, aside from these 3 categories of interventions that could be taken to address ghost gear, there should also be a lot of initiatives on awareness, education, and research. This includes training, especially for those involved in the fishery sector itself, from industry and from the small scale and artisanal subsector, knowledge sharing, stakeholder engagement, citizen science. And for all these interventions that I've mentioned, prevention, curative, mitigation, and awareness, there can be implementation mechanisms which comprise of voluntary actions. This could be fishery certification, market-based instruments as well. Then for the purpose of the study, I'd focus on the regulation and legislation and what governments can do for these command and control measures to be implemented in national governments, in the national jurisdictions in Asia Pacific, and of course, information, education, and communications campaigns. Now, I'd like to note that these measures are not mutually exclusive, and there could be a suite of compatible measures that could be undertaken by national governments. But I would like also to note that it should governments should prioritize prevention measures rather than curative and mitigation measures, so as not to introduce ghost gear into the oceans in the first place. And it's also important to tailor fit the solutions, because some sectors within the fishery sector have different operational considerations. So some interventions may work may work better in commercial, and some may work better on small scale fisheries. Now, for the teaser, this is just some of the case studies that I've taken on and discussed further in the study. I've looked at case studies in Indonesia on their gear marking, and in Vanuatu on their tracking technology for their fisheries aggregating devices. Some of the lessons learned have been making these interventions for prevention already integrated at the point of manufacture of the gear, and having more technology that would lower the costs of these interventions. Then from the Philippines, for mitigation, there have been biodegradable gear, such as the use of buri palm fronds here, to make sure that they are not, these plastic fishing gear are not being used as much. And then for the curative and recovery measures, I focus on studies in Myanmar, which the lessons learned of which are focused, our interventions should be focused on hotspots in the region, and where there are ecosystems that are highly vulnerable, and the efforts for recovery should be focused there. And also recycling efforts in Thailand through their upcycling initiatives for engaging fishing communities to upcycle their ghost gear and making them into face shield, into bottle openers, such as this Moby whale here. Now, this is more of a sneak peek, but you could look at it later on in the study itself. This provides some guidelines and guidance for national governments on what implementation mechanism that they could take on each intervention, and what the responsible parties are. For example, if they are fisheries managers, if they're port operators, if they're gear manufacturers, and applicability to which subsector within the fisheries industry, and also the costs involved, as this is particularly an issue in Asia Pacific, and some of the implementation notes. So I'm just putting this here for a sneak peek, but later on it would be good to provide guidelines and guidance for national governments when they are choosing which interventions would be best to address ghost gear in their respective jurisdictions and considering their local conditions. So this is for mitigation, curative, and awareness and education as well, are all included in these guidance. Now, to conclude the study, these interventions that I've mentioned from all different kinds of ways to address fishing gear all seek to change human behavior and also promote innovations in technology. Now, there are already binding and software instruments, especially for gear marking, for example. Now, all we have to do is translate these best practices to implementation mechanisms on the ground. But it's also important to note that we should prioritize, of course, prevention measures and circular economy approaches, which tries to reduce the introduction or prevent the introduction of ghost gear into the ocean. And the next steps would really to establish policy and regulatory frameworks. These include rules and guidelines to implement, for example, best practices for local conditions, industry incentives, and recycling and waste handling measures that are specific to ghost gear and marine and pollution from waste from the fisheries sector. Now, these behavioral and system changes are envisaged to address marine pollution from the fisheries sector, and I hope that these recommendations and best practices in the study would contribute to promoting the marine debris rule of law in Asia Pacific. So I'll end with that, and thank you very much for this opportunity to share a preview of the study in this marine debris rule of law book. Thank you very much.
Thank you so much, Rocky. So we have had our 3 presenters, and we have some questions. We have 2 questions in the Q&A button. You can still type in your Q&A there in the button, or you can raise your hand. But we will start with the first question. I think here is from Celine. She's asking a general question for I suppose 3 of you. She would like to ask a general question. Has the legal architecture of the marine plastic pollution started to make its impact in environmental litigation? If not, will marine plastic pollution become a hot topic for environmental litigation? I would like to invite Alice first for this. What are your thoughts, Alice?
Yes, a really important question, and obviously one on the back of climate change litigation is probably front of mind for lots of people. This isn't an area that I've done extensive research into. Of course, I'm aware of many actions that are taken at the domestic level under domestic laws, and there are a number in the United States, for example, that have made headlines where certain beverage companies have been sued for nuisance, or regulators are sued for failing to properly regulate plastic pollution. So there are those sorts of things happening at that domestic level. But as far as I understand in the sort of domestic, sorry, I beg your pardon, the international sphere, it's the nature of these fragmented laws is that, you know, part of what, you know, I guess amounts to them being ineffective is around this issue of liability and compensation for plastic pollution. So that's, as I understand it, there are many initiatives that are trying to get, you know, those sorts of regimes attached to either existing agreements, or of course it could be part of a new international agreement if that were to proceed. But as I said, this is not an area that I've researched in great depth, and perhaps there's someone in the audience or one of the other speakers who has knowledge of specific efforts to bring either private actors or states to account for their failure to manage plastic pollution that ends up in the oceans.
Thank you. Alice, Beishuan or Rocky, you want to add to that answer?
Yep.
Yes. Yep.
Beishuan, go ahead.
Okay, thank you. I want to share a case in China. What was happened in 2017? There's a domestic NGO, environmental NGO. It filed a suit on the 3 major Chinese food online delivery companies because they find that when the users order the food, they use it as a default setting to give the users the single-use food container made by plastic and plastic tablewares as well. And they think this kind of action made a very significant damage to China, the environment of China, and they asked these 3 companies to pay for this damage. And after they filed the suit, the 3 companies, they adapted their settings. So when users are ordering food, you will have the option saying whether you need the single-use food container or you want to pay for the single-use container. So after they made that adaptation, the NGO just removed their application from the court, and they finally made a conciliation. So I think, yes, the litigation both at the domestic level or maybe in the future at the international level will make tremendous difference to our combat against the plastic pollution. Yeah, that is my thought.
Thank you, Beishuan. Rocky?
Thank you very much. Just a general comment. Of course, this is not related to the ghost gear issue, as the ghost gear has been mostly a gap on most national jurisdictions here. But in terms of litigation, and especially from the context of the Philippines, and I would presume developing countries as well, it has mostly to do with the lack of or the weaknesses in implementation, and this has been tried to be addressed to more litigation. For example, there are cases or pending cases. I hope Professor Liza could expound later on if she has the time on like the implementation of some of the legal frameworks that are already in place, but have not been really implemented by government agencies that have the mandates to do so. So I would, at this stage of our marine pollution and marine litter management in the Philippines, at least, it's at this level that we are still trying to implement this, and litigation has been can be seen as one of the ways to expedite that process as well.
Thank you, Rocky. Lisa Oz, are you still there? Yeah, would you like to say some few words? And also there is a question for you specifically from Prof. Lin Heng.
Yeah, I think they're related. So yes, so right now we there's a litigation that we're preparing. We actually followed the prerequisite of sending a notice to sue to the government, because under the current system that we have, we require 30-day notice to the government to send a notice to sue the National Solid Waste Management Commission, which is consists of 14 government agencies. Basically, this is a lawsuit seeking for a writ of kalikasan, or if translated, a writ of nature, and a writ of continuing mandamus. So the writ of kalikasan is aimed at protecting the constitutional right to a healthful and balanced ecology, which is an enforceable right in the Philippines. And because of the damage caused by the plastic pollution in 2 or more cities or provinces. So we're joined by Oceana together with 49 co-plaintiffs have signed as petitioners. This include lawmakers at the local level, a senator, former senator, fisher folks. Majority of also the petitioners are youth petitioners, and citizens, as well as public interest litigation groups. Will be filing a suit next week. Actually, we were just a bit delayed because of the lockdown measures, so we had closures for physical filing with the Supreme Court. But we are preparing. We're in the final preparation stage for sending the petition to the Supreme Court, and hopefully, we could ask the court to issue also the writ of continuing mandamus to compel the government agency concerned, the National Solid Waste Management Commission, to issue the list of non-environmentally acceptable products, which is defined under the law, that includes single-use plastics, as well as also ensure the phasing out of the single-use plastics in our country. So hopefully, we will be quite successful with this lawsuit. We also, this is also a climate lawsuit, because we are alleging that the Philippines is bound under its nationally determined contributions and the Paris Agreement to ensure the reduction of greenhouse gas emissions. So the continuing insistence of or inaction of government for 20 years in doing their mandate is actually aggravating the climate change as well. So basically, that's a short picture about it. So we will be having press releases, so just watch out for those information coming out of the Philippines. Thank you.
Thank you, Lisa Oz. So for to shortly answer your question, Celine, so yes, it will be a hot issue because we have so many problems, specifically also liability, compensation, restoration, and who's going to deal with them specifically. Yeah, so this is just a start, and then we are going to have like many, not just litigation, but also research and action plans and all kinds of things going on for marine plastic pollution, I hope. Okay, so back to the questions. The second question is for page 1. Page 1, don't you think that a new legally binding agreement, this is from Patricia Parkinson, don't you think that a new legally binding agreement on the prevention of plastic pollution would remedy the fragmented legal framework and will allow for addressing the problem of plastic at all stages of the plastic life cycle, rather than at the end or which stage of plastic life cycle?
Yep. Thank you, Linda, and thank you, Patricia, for this question. I think I want to answer this question from two perspectives. So on the one hand, yes, I totally agree with you that a new legally binding international agreement that adopted the all life cycle approach will be significantly complement the existing international legal architecture. But this is ideally speaking. But as I said, we need to think about states, maybe as well as the industries and also individuals whose interests will be affected by such kind of international legislations. Taking China as an example, if we adopt such a kind of international instrument, at current stage, I think China still lacks both the incentive and the enough capacity to deal with the plastic pollution or just to upgrade its industry. I think this situation is also shared by many in many other developing countries. So on the one hand, it's what kind of law we should have, and on the other hand is what kind of commitment that state can take and can actually realize it. So I think, yes, if we have such a kind of international treaty in the future, we need to make a fine balance between these two sides and also taking into the needs and the demand from the developing countries. Yes.
Okay. Yeah, so I think that's also a very good question. APCEL is also together with other partners of WWF. We are going to launch a report from Asia and the Pacific, well, specifically Asian region, on the importance of international treaty in marine plastic pollution next week. We will have the link on the APCEL website. At that report, we sort of want to present what the governments in this region want specifically, what kind of push, what kind of action that are needed to have the international agreement on marine plastic pollution. Of course, we also understand that we are in, international agreement fatigue, as an addition to Zoom fatigue also. But yeah, but because of the complexity of the marine plastic pollution issues, I don't think any countries can handle them, by themselves, like individually. It needs to be, a common efforts from the states. Okay, so we go back to the questions here. Again, in the Q&A, we have Kaya. Kaya congratulated us for the talk and the book launch. Thank you, Kaya. I would like to ask your opinions about collaborating with scientists and engineers when incorporating solutions into legal frameworks. Is that currently being put in place? And how do you think this can be part of developing legal frameworks? For instance, with regards to biodegradable gear being a possible solution, there have been research papers starting from biodegradable materials might not be the best solution due to the complexities with the production and whether they can disintegrate into bio-based materials in the environment. So I think I will invite Rocky first because this is in your neck of the wood, Rocky.
Sure. Thank you very much, Kaya, for that question. And of course, my opinion, it would always be good to collaborate more with scientists and engineers, of course, in the development of legal frameworks to address the issues. As to what are the initiatives that are being put in place, for example, for Ghost Gear in particular, there is a cross-stakeholder alliance called the Global Ghost Gear Initiative, GGGI. You can look it up, and they have been collaborating with a lot of government, national governments, as well as the UN agencies, particularly FAO, on developing solutions for ghost gear. And they include members from academia and science and and all these researchers to develop solutions to address ghost gear. Now, there are a lot, I mean, from all the interventions that I've mentioned, I think I could name a number that would really need a lot of scientific interventions or scientific assistance. For example, just to give some examples, for example, for gear marking materials, what are the best materials that can be used there to ensure that they don't end up as waste again in the first place. And then for the technology, for location, for the gear location technology, what would be the best technologies that could be developed? So that would be good for with the tech people to develop. And then for mitigation, of course, biodegradable gear, what biodegradable gear are best suited, especially to the local conditions, especially what are already in those areas in the first place. For example, the Philippines, we have the palm fronds of the palm buri, which we have used as a biodegradable gear, and especially also as the recycling, because nets are mostly used consist of mixed use materials. So there's this challenge of recycling them, especially if you involve local communities in far-flung areas, local fishing communities. So this is an issue as well that would really need the assistance of scientists and engineers to develop further solutions on. So I will definitely agree that we need more science to help in the development of these legal frameworks.
Yeah, agree. Thank you, Rocky. Alice, you want to say something on the importance of incorporating engineers and scientists in developing legal framework?
Oh, I mean, I think that Rocky's answer was really comprehensive on this one, and he's probably got the detailed expertise to address it. But of course, you know, environmental law, we all know that it's constantly intersecting with scientists and scientific issues, and the more we can do to make sure these different communities, for want of a better word, are coordinating and communicating with each other, the better. And I think there are, you know, important vehicles for making that happen at the international level, sort of more generally, which can hopefully flow through to some of the specifics around marine plastic pollution.
Thank you. Pei Xuan, you have anything to add to that?
Yes, I think Rocky and Alice has made very comprehensive answer. And I just add one thing from China's experience. I found that China's the newly adopted solid waste law just inserted many provisions to promoting the biodegradable plastics. And I'm not sure whether during the process of domestic legislation, there is a good mixture of scientists and legislature, and maybe economists. But I think as for China now, the consensus is that to promoting the biodegradable plastics. And I also read the report that China is the world's biggest market for that. Yeah.
Thank you, Pei Xuan. Always very interesting to hear things from China. Very innovative and amazing, I would say. Okay, so we have our last question here from Kanika Jamwal. She congratulates us on the book launch and for the talk. Thank you, Kanika. And she's looking forward to read the book. Of course, please be our guest. We want as many people to read it as possible. So her question is, do you think CSR, corporate social responsibility framework, could be used as a tool for managing both preventing and curing MPP, marine plastic pollution? What do you think? Corporate social responsibility. Alice, you want to take a stab at it?
Sure. Well, I mean, and this actually is quite pertinent to our chapter, because we got to that point of thinking about, well, how do we incentivize exports, taking the plastic off Pacific Island countries? And in our research, we discovered that important initiative of the Moana-Taka Partnership. And associated with those sorts of arrangements are product stewardship arrangements and commitments from companies that say, we we're committed essentially to taking the waste back and dealing with it, either recycling it or recovering it for other uses, and we'll meet those costs. So that's absolutely necessary and vital, and we see many examples of where that's working. But I'll say two things. One, of course, is that should not be at the expense of laws and proper legal frameworks to actually make sure that these sorts of initiatives are, not merely talk, but are actually put into action. We always see this need for, if you like, hard law or regulation to run in tandem with corporate social responsibility initiatives. The other very important thing, I guess, to note is that it's typically the larger companies that have these sorts of commitments and policies in place. And we know, especially from what Rocky was just describing to us about some of the problems he's been researching, we know that it's often not the larger companies, but the smaller ones who have certain responsibilities around the generation of plastic waste that ends up in our oceans. And unfortunately, their corporate social responsibility, isn't really a factor in seeing those sorts of entities and corporations act responsibly. So again, I would just go back to saying we need hard law. We need hard law at the domestic level. We need to explore the kinds of initiatives that our paper has discussed in the regional context. And then, of course, we still need those international frameworks that we've been talking about and trying to remedy some of the gaps and holes in those. So it's really just a holistic approach. I certainly see corporate social responsibility as part of the solution, but not the only one.
Thank you. Any additional thoughts from Rocky or Pei Xuan?
Yep, can I just chime in? Definitely corporate social responsibility can be a useful tool in the context of ghost gear, but also applicable to other plastic waste. Initiatives such as the beach cleanups have been really helpful to get the nets from certain beaches here in the Asia Pacific. So that has been really helpful. And also some industries and businesses actually, as part of their CSR, but also as part of how they can continue their business, they have the responsibility to clean up. So for example, for resorts and tourism establishments, they have been involved in recovery initiatives, not just because it's their CSR, but they actually have to clean up these areas and the reefs, for example, in the first place. So that's part of their CSR, and it's also as a function of necessity. But I would really definitely agree that this is not enough. There are certain market-based instruments as well that they could take, but this would definitely need a holistic approach with command and control measures, regulations and legislation, and these CSR and market-based instruments, as well as information and awareness campaigns as well, to really address the issue in a holistic manner.
Okay, thank you, Rocky. Pei Xuan, you want to add to this question? To this answer of this question? Yeah.
Yeah, I also think, yes, the corporation social responsibilities are very important. And we can also see there are many GN companies, either at their domestic level and international level, they are lobbying directly, or they're forming, or they are backing the NGOs to put forward their proposals to influencing the ongoing legislation. But I want to mention that we need to distinct the real fulfilling of corporate social responsibility, or these companies are doing like greenwash to hide their responsibilities instead.
Thank you, Pei Xuan. Okay, I'm closing the Q&A session for questions, but this is the last question from Patricia to Pei Xuan again. Is there any action in China to reduce the production of the $2 shop products, which are an important source of plastic pollution in other countries? I apologize if you already addressed this in your presentation. From Patricia Parkinson.
I don't think so. And so currently, I think China's main attention is paying to the single-use product. It has the policy document that's asking the plastic-intensive industries to reduce the use and the produce of single-use and non-degradable plastic products. But I'm not sure if other plastic materials and products are already on the list. I don't think so.
Yeah, so there is still a lot of $2 shops everywhere, which unfortunately my kids really love. Okay, so we still have Professor Rose-Liza, we still have Stefan and Jolene here. Would you like to say something or add some of food for thoughts for our discussion today?
Thank you, Linda. No, I think that that's been a very rich discussion, and I just think that everyone here has so much to share and learn from one another, and I hope that this is just the beginning of as we work together to try to address marine plastics pollution.
Thank you so much, Jolene. Stefan?
Well, you know, thanks a lot. I mean, there have been quite a few takeaways today, and I think the message and the task for us is, I mean, to spread what we've been discussing today, and especially, you know, the book. And that's our task, that's our job, and we will very much work on this in the days and weeks to come, and I'm looking forward to that. It's been remarkable how diverse, you know, the debate and the discussion, also the questions have been, you know, from, you know, environmental issues in the core sense up to CSR issues, corporate social responsibility, to put it on a broader, you know, plate. That was highly remarkable and very, very interesting. So thanks a lot to all of you once again for today.
Thank you. Lisa Oz?
Yeah, this likewise, this has been quite an enriching session, and I hope that with this, you know, publication will trigger a lot more work from all of us, as well as, you know, action, of course, that we all need in order to deal with the marine plastic pollution. So thank you so much to everyone for your participation.
Thank you so much, Lisa Oz. I would like to say thanks to Alice, Rocky, and Pei Xuan for your hard work, and also for the other authors who are, you know, giving us their time, their sweat, their tears, hopefully not blood, but maybe a little blood, to make their papers, to make their articles in accordance to what we wanted to have in our publication. And this is not the end of our efforts, I suppose. As Stefan just said, this is the beginning of what we have started together. And from the bottom of my heart, I would like to say thanks to also all the partners, Cebu University School of Law, CAS Rule of Law Program, and KLRI in South Korea. I think when something as massive as this, as you know, the issue is very massive, and there's so many parts that we have to work with. It's very reassuring to have partners that would have your back. Like no matter where you are, they will like help you out. So I think that's what we have worked here together is a life lesson for me, and also for the other partners here. And yeah, let's keep on doing this, guys. We still have a mammoth task in front of us. So thank you very much for all the participants. I'm sure you still have lots of questions. You have lots of comments. You can send it to us in APCEL or in CAS or to UC School of Law or to KLRI. We'll still be here for you. You find our contacts in our websites, and look forward for more APCEL activities in our APCEL websites. We'll have the agenda there for you, and also it's always for public and for your participation. I suppose please enjoy the book. If you have time, you read the book, and like in the future, we will try our best to do better than what we already done today. I suppose that's from us in APCEL and our partners, CAS, UC School of Law, and KLRI. That's it for today. Thank you so much for your participation. We'll see you again in the next activity. Thank you so much, everybody. Stay healthy.